Welcome to On the Case with Briffa. I'm Debra. Today I'd like to talk to you about the fashion brand Karen Millen and an interesting case to do with its trademarks. The designer Karen Millen set up her fashion business in 1983 and named it after herself. She worked in the business for over 20 years and grew it into a household brand. In 2004, she decided to sell the business to an Icelandic private equity firm, and when she did so, she entered into various restrictive covenants regarding the use of the trademarks associated with Karen Millen. In 2011, Karen Millen announced her intention to return to the fashion business using the brand name Karen. There were various disputes over this and a settlement was reached in relation to the UK and EU. However, Karen Millen felt that the position was not clear in relation to her use of Karen or Karen Millen in the US and China. In 2015, Karen Millen applied to the UK court for assistance in relation to giving negative declarations regarding the restrictive covenant she had entered into when she sold the business in 2004. Karen Millen's case to the court was that the restrictive covenant should not apply in relation to the US and China and her use of the trademarks Karen and Karen Millen. Ultimately, the court found that the restrictive covenant did apply to Karen Millen's use of the trademark Karen Millen in relation to the US and China. The court also found that the proposed use of the mark Karen was not clear enough for the court to decide on at this time, but implied that if further information was given, then potentially the use of the brand Karen could be allowed in relation to China. The court found that the trademark Karen Millen is highly distinctive and that therefore, although consumers in the US might not be able to predict that Karen Millen would expand it out into the homeware market, if it saw products in the homeware market, it was likely to associate those with the retail company, and so therefore, if that was not the source, that there was a likelihood of confusion between the two. The takeaway point for designers to think about before naming their business after themselves is that if they intend to sell it in the future, there may be various restrictions on how they can use their name going forward in relation to the same business and possibly other ventures as well. I'm Debra, and thanks for watching On the Case with Briffa.